slideshow.
All right, are you seeing it now?
Okay, today we have Angus and Terry presenting a webinar on discrimination. This recording is for internal use only. And Anne, you have a disclosure that you wanted to give?
A disclaimer.
Disclaimer.
Yes, just a typical webinar disclaimer. This presentation is not specific legal advice. If you have specific facts that you'd want us to provide an opinion on, please contact us or contact the association's legal counsel. We'd be happy to assist. This is just for informational and educational purposes, and we hope you all find it useful.
And are you guys seeing the presentation right now, the big Angus and Terry logo?
We are, yeah.
Okay. All right.
Yeah, so let me just introduce ourselves. Julie couldn't be here today. She's still recovering from COVID, so she sends her regards. She wishes all of you well. She's much better now, though. I'm Anna Cunha. I'm a partner here at our Walnut Creek office. I oversee our general counsel department. I'm here with my partner, Colin McCarthy, and senior attorney, Lance Stewart. For those of you who are familiar with our firm, you know that we are a full service firm that specializes in common interest development law. We have a general counsel department and also a construction defect department. We do all sorts of things. So if you have questions of what we can or can assist with, contact any one of us. Also, Ivy Vu, our client services director, she's available to assist. We do have a special offer for any new associations who need new general counsel or need to switch to another general counsel. We offer special rates for the first 12 months to new clients and also free board training. So keep us in mind for your associations. Now I'm going to turn it over to Lance.
Okay, and let me know if anyone has trouble seeing or hearing the presentation. This is, of course, the title shot, Fair Housing Board Obligations in Response to Discrimination Claims and Disability Accommodation Requests. Really appreciate Paul reaching out on this topic. This is something that comes up all too often, and all too often isn't really handled the way it needs to be handled. This is an incredibly complicated area of the law with huge potential consequences for our clients, for the HOAs. Things aren't handled just right. It's going to be a bit of a lightning round of a presentation. We're going to try to keep this down to 30 minutes, and it's, like I say, a very complicated area of law, so we're going to try to hit some major points as we go along. You'll hear from all three of us at different points. We're going to touch on, in particular, the idea of race discrimination, but also other types of discrimination. And then we're going to devote some time specifically to disability discrimination concerns and specifically requests for disability accommodation. But the big points we want to make sure get out there. If you hear anything along these lines from anyone in any community, I'm being discriminated against because of X, I have this disability, I have this medical condition, anything along those lines at all, your first stop is counsel. You want to get counsel involved right away. These are matters that can be handled fairly quickly and even sort of fairly administratively, but if they're not handled right, they can blow up into great lawsuits, as we see far too often. So big points are, don't ignore these issues when they come up, get counsel involved quickly, and having counsel involved can make the difference between much less liability or hopefully no liability and having great big liability. And when I say great big liability, what I mean is, we'll talk about this more at the very end, we see these claims, again, things that should have been very administrative, simple decisions blow up into legitimate claims, the way the law is written, for 6 or 7 figures against our clients' nonprofit HOAs. Okay, some basic concepts to understand about where these things are coming from. One big concept is the idea of a protected class. And that is the idea that a group of people historically have been treated worse than other people because of their particular membership in a particular class. Black people treated worse than white people, women treated worse than men, people who identify as lesbian or gay or bisexual being treated worse than people who identify as straight. The point of these laws is to try to protect people from continuing discrimination. That's the idea behind a protected class. So race, gender, sexual orientation, familial status, disability. These are all particular groups of people that the law wants us all to be paying attention to and make sure that they're not treated worse as they have been in the past. California law is a little broader than federal law in terms of the categories of protected classes. Depending on what part of the law you're looking at, there's usually 15 or 16 different classes. The big thing to take away from this is if anyone is saying I'm being discriminated against because of my anything, any characteristic about me, the way I look, anything at all, get counsel involved. They'll try to sort out whether they have a possibly legitimate claim under any particular law. Just if they're saying I'm being discriminated against, get us involved, get the HOA's general counsel involved. The HOA is considered a housing provider. We commonly say that HOAs are corporations, and they are, but there are instances where the law treats an HOA as a sort of quasi-governmental entity. And this is one of those times. Under both state and federal law, HOAs are considered housing providers, which means they must comply with laws intended to protect people from discrimination. That's where this is all coming from. And you heard me say a moment ago, if anyone alleges discrimination, contact counsel. When I say anyone, I literally mean anyone. They don't just have to be a homeowner. A tenant, a vendor. We had one recently where a vendor's employee was alleging what amounts to sexual harassment by a board member. That falls under this. Employees of the HOA, even guests. If anyone that's setting foot in the community is alleging any form of discrimination, get counsel involved. Let us sort out what type of claim might be at stake and what the HOA should be doing about it. Okay. You've heard me say a couple times, this is a hugely complicated area of law. There is, for starters, the Federal Fair Housing Act. There's the Department of Housing and Urban Development regulations, which sort of enact the Federal Fair Housing Act. There's the California Fair Employment and Housing Act and the California Code of Regulations that set up the Department of Fair Employment and Housing, who some of you have probably dealt with or worked with us in dealing with. And then there's the California Unruh Civil Rights Act. Do I expect you to remember all these names? No, of course not. What I want you to take from this is it's a hugely complicated area of law. Do not trust these issues to, the board's sort of knee-jerk reaction of, oh, this person's just playing the race card. Oh, they're making up this medical condition. It's nonsense. They don't have an allergy to their carpet. They're just playing the race card, whatever. Do not trust these situations to that instinct, which is far too common. It's a hugely complicated area of law with huge stakes. Get us involved. What about the Americans with Disabilities Act or the ADA? A lot of times when somebody is raising a disability concern, they will cite to the ADA. They'll go on Google and find some choice provisions from that law and throw that in your face. Technically, that law usually doesn't apply to HOAs unless some part of the HOA is open to the public. But from your standpoint, it doesn't matter. What they probably mean is the Fair Housing Act or the California Fair Employment and Housing Act. Don't worry about whether they're citing the right law if they say ADA. If they say ADA, get counsel involved. And I hope I'm sounding like a broken record because please get counsel involved. Too often we're seeing more and more folks coming to us with these issues at the beginning so that we can make sure they're handled properly and protect the HOA. But too often they're coming to us at the end of the situation when things are much harder to deal with. We're obviously not going to go through all the aspects of the law that come into play here. There's just too many, but to give you a taste. The Federal Fair Housing Act, 42 U.S. Code 3604, says that it's illegal for a housing provider to discriminate against any person in the provision of services or facilities related to their home because of protected classes or because of a disability. That's sort of a basic idea in how this plays out for HOAs. You can't treat somebody differently in how you apply HOA policies or what they have access to in the HOA or how the board responds to them because of their race, color, religion, sex, familial status, national origin, or because of a disability. We'll dig into disabilities more in a little bit, but something to understand about disabilities. Here again, it doesn't matter if the person you're talking about is a homeowner. If they're a resident or they're intended to be a resident. We had one recently where somebody's saying, my father-in-law is going to come live with us. These laws apply to the father-in-law. He's not a homeowner. He hasn't been living there. He's going to live there. These laws apply to them. The HOA still has to make sure that they're complying with these laws as relates to the homeowner's father-in-law. So basic idea, you can't discriminate against anybody on the basis of these things and how the HOA interacts with them. Okay, we're going to dig into race discrimination a little bit. First, by way of illustration, Anne is going to talk to you a little bit about some of the situations that we see or are seeing. Anne?
Yeah, well, I wanted to talk about specifically one situation I'm dealing with. We're dealing with a DFEH complaint, and we are working with the board and the manager to respond to the complaint. But this specific complaint is coming from a homeowner who throughout the years has made lots of complaints about children playing in the playground next to her home, about noise in the playground. So after almost 10 years of hearing her complain about kids playing, I think the board and the manager had been numb to certain complaints. But more recently, earlier this year, some of the kids, particularly some teenage kids and their friends, were talking back to this woman, and one of the kids' friends, so that friend doesn't live in the development, but a friend of someone who does, use the N-word on this woman, and she complained to the homeowners association. And the whole basis of her DFEH complaint is that the association didn't do anything about people saying those kind of things to her. The association, fortunately, it's not that they didn't do anything. They actually hired our office. They didn't tell us about the racial slur, but a letter was sent from our office about the harassment to the homeowner, and telling her that this is not something the HOA supports or condones. We're doing our best to handle the noise issues, which is what we believed it to be. The owner, whose kid's friend said that, was recently called to a hearing months after the incident. They didn't find the homeowner and basically said, "Thank you for showing up to the hearing. Please stay away from that woman," is what they did. So we will argue that they did something about the complaint, but the issue is going to be whether they did enough, and what powers they had to stop someone's kid's friends from saying those kind of things, is going to be at issue. And Lance will talk about what the the regulations look for as far as the HOA's involvement in these types of situations.
Absolutely, and thanks, Anne. This is a great illustration of how these things can play out from the HOA standpoint, because the HOA can be potentially exposed for really anything anyone does in the development. And we're going to break that down a little bit. So obviously, if the HOA itself is engaged in discriminatory practices, we're not going to review your architectural request because you're Black, whatever. Of course, the HOA is exposed for that. That's the starting point. The HOA is directly liable for its own discriminatory housing practices. The HOA can also be directly liable for a discriminatory act by somebody who is an agent of the HOA, if the HOA knew or should have known of that. So a board member is running around saying, "Hey, I'm going to give you a bunch of violation notices because you're gay." The HOA could be exposed to that if the HOA can be directly liable for that if the HOA knew or should have known of that. But it doesn't stop there, because the HOA is also vicariously liable for the acts of its agents or employees, whether or not the HOA knew about it. So, a manager is saying stuff they shouldn't say, a board member is saying stuff they shouldn't say. The HOA can be, this is the same idea as a boss being, or a company being liable for the acts of its employees while they're doing their job. The HOA can be vicariously liable for the acts of its agents, whether the HOA or the board knew what was going on or not. These are obviously very complicated things, but the one we're going to emphasize for purposes of this presentation is third-party liability, which goes directly to Anne's illustration. And this is something that's coming up a lot. It can be very scary when you first start to think about it, but there is a way of dealing with these concerns. So the HUD regulations say that the HOA is directly liable for failing to take prompt action regarding a discriminatory housing practice by a third party, meaning someone who is not an agent of the HOA, not a manager, not a board member, not somebody that's acting on behalf of the HOA, somebody who's in the HOA. A resident uses a racial slur against another resident. The illustration Ann just gave of a guest to the development uses a racial slur against somebody who lives in the development. The HOA is potentially directly liable for that third party if the HOA knew or should have known about it and had the power to correct it. Power to correct means depends on the HOA's control or any other legal responsibility for that third party. The short version here is that you're going to think about this in terms of governing documents violations. If somebody in the development is discriminating against somebody else on any basis, and the board has concluded that that's what's going on, you're going to treat that as a violation of the nuisance provisions. But what we're going to do right now is Colin's going to take a moment and talk you through a situation he handled recently to give you an illustration of sort of the procedure that we recommend when somebody is alleging that somebody else in the community discriminated against them. Colin?
Yeah, hi. Thanks, Lance. So I have a current client where there's an ongoing dispute between two homeowners, upstairs, downstairs situation, where there is a battery of complaints back and forth between the two unit owners about noise. The lower unit owner, in one of his many, many emails to the management company, complaining about the upstairs unit, said, I'm being discriminated against. He actually, in that context, said that it was one of the board members who was discriminating against him. But in the context of that allegation, the response was, well, let's find out, what does he mean? Well, why do you have this? So the board voted to have an official investigation into this complaint, and I was asked to do that investigation. And the starting point for that investigation is to ask the individual, what did you mean by that? And so I sat him down with another board member who was not implicated, and the management company, and did a Zoom interview, and he explained 3 or 4 different bases for why he felt like he was being discriminated against. And actually, none of them which involved the other person who he had the noise complaint with, but one of whom was a third party, the security company. So the gist of his complaint in regards to that third party over whom the board would have the power to correct was that the security agency investigating these noise complaints was favoring the other owner because she was Black and he was Asian. And that because of the prevalence of the Black Lives Matter movement at that time, they were singling him out as an Asian person and favoring her in terms of responding to these noise complaints. So then the investigation takes on it's not necessarily a straightforward complaint, but you have to interview the people who are involved in that decision. So you interview the board members who hired the guy and who interacted with them, and the board members who were alleged to have discriminated against. And then you culminate with an interview of the security person, the third party, and ask them about all the information that you've gathered to date. And then point blank, did you discriminate against this person? Did you take into account that his race or her race in your response to the complaint and to the noise complaints? And the reality of the response was informed by everything that had happened before, which was that the noise complaints were, he responded to every call he got. He even gave that homeowner who made the discrimination complaint a special line to text him. Nobody else was allowed to text, but he made the complaint that if you don't, you will not hear the noise. If I call, she'll stop making the noise. So I want to be able to text you. And so the security person accommodated that request. But because he was unable to substantiate any of the noise complaints from the upstairs, it was the person's view that he was being discriminated against. So, and then once you're done with that, the next step is to write your findings to the board and recommend a course of action. In this case, there was no real action to correct. It was just to enforce the governing documents. There's an issue about the floor upstairs, so that obviously has to be taken care of. But assuming that the board takes my recommendations, they'll have confirmed they'll have done something. If there's a later complaint, there will be evidence that the board took a look at this and didn't find anything.
Thanks very much, Colin. And that sort of, again, the overarching point here is not that you guys should be trying to go through this process yourselves, but get counsel involved. And the HOA's legal obligation is not to fix discrimination in the hearts and minds of people in the community. That's not the point here. Or to be able to read people's minds and know what's truly in their hearts. The HOA's legal obligation is to look into it and document that the HOA looked into it. Not to necessarily, read people's minds. So best practices when somebody alleges discrimination of any sort, again, contact us, contact the general counsel. But as Colin laid out, you're going to work with the board to conduct an inquiry. You verify the complaint, investigate, talk to witnesses, document the evidence, and the board is going to sit down with that, or our office is going to sit down with that and make a recommendation and assess, does discrimination seem to be a factor here? If discrimination seems to be a factor, I had one not long ago where in the middle of this inquiry, where one homeowner was complaining about their neighbors, just endlessly complaining about them over and over and over again. And the more we looked into it, there didn't seem to be much to complain about. But meanwhile, the people she's complaining about are saying it's because of our race. She doesn't like us because of our race. And lo and behold, as we're doing that inquiry, and the homeowner knows we're doing that inquiry, she gets on the phone with the manager and says, well, you know how that race is. They're slippery. They're slimy. Thank you very much. We have a winner. That's the sort of information we're looking for to see whether this should be treated as a violation of the governing documents. And as with anything else, that's what the board is empowered ultimately to do. If it seems like discrimination is a factor, you're going to treat that usually as a violation of the nuisance provision of the governing documents. And from there, it's, the routine. You're going to send a courtesy violation letter, which is what we did in that instance. If it persists, you're going to hold a disciplinary hearing and on down the usual enforcement process. If the board is unable to conclude in consultation with our office that discrimination is a factor, you're going to document that determination. You're not going to say necessarily that it's not happening, but that we weren't able to conclude that that's part of what's going on. Does that mean you don't deal with the other aspects of what's being complained about, the noise, excessive smoking, whatever else? No, you still pursue those issues. But when it comes to the discrimination component, the board's going to look at that and work with our office to look at that in terms of, does discrimination seem to be a factor? And if so, we're going to treat that as a violation of the nuisance provision of the governing documents. That's the long and short of what you're going to do here. And the point of all these things is when they come up, you want to make sure the board looks into it and then documents that it looks into it. That's the point of all the letters that Colin was talking about a moment ago. Okay, we're getting a little bit tight on time here, so we're going to talk about disability accommodations. Anne, could you sort of quickly lay out what you were dealing with recently in terms of practical handling of claims for disability accommodations when they come up?
Yes. So a recent situation I was dealing with is a parking accommodation situation where someone was using the guest handicap parking space because they were larger, and this resident had a van that had a ramp, and so he needed to have a bigger space, and his assigned parking spaces didn't have that space. He never asked for an accommodation. He just started using it and felt he was entitled to. He had a handicap placard, and there was a dispute. He was notified that he was in violation of the parking rules because he is not a guest, and he didn't have special permission to do that. But at my advice, we handled it very carefully. Just because somebody's breaking the rules, they're handicapped, they have a van for wheelchair access, and the placard. It was more, the notice was, hey, you're in violation of the CC&Rs and parking rules. It looks like you need a special parking accommodation. Let's work on that. And that was the whole approach. He had a relative who was an attorney, so we ended up talking about this proper solution. The board was concerned that he's taking, not only that guest parking space, but he has 2 extra spaces in an association where parking was scarce. So what we did in that situation, I worked with his lawyer. and we switched the assigned parking space. These are deeded spaces. So he was then temporarily assigned, assigned to him use of one of the guest parking spaces. It was renumbered. Everything was done formally. We did a recorded covenant because in his grant deed, he had certain assigned spaces and things had to be repainted. So the agreement that we came up with is he would get a different parking space, one with that can accommodate his van with a wheelchair ramp, and he would give up his assigned space, and that would be marked guest parking. We had it in a recorded covenant, and part of the terms in that is saying if he ever moves out or sells his unit, he would have to notify the association, who would then restore the parking spaces back to what matches the governing documents and the grant deed. So this is something obviously associations would need to work with council to do, but the board was happy that a resident is not taking up more parking spaces than they really needed. And he was happy that it was formal and he wasn't getting violation notices time after time when he just really needed a larger parking space.
Thank you very much, Ann. And this idea of a covenant becomes very important with how you guys handle these as a practical matter. So when it comes to disability accommodations, disability issues in general, the point of the law is to make sure that in all the various laws we talked about is to ensure equal use and enjoyment of the homes for everyone. Somebody's medical condition shouldn't prevent them from having the full use of their home. From an HOA standpoint, you have two basic obligations. One is to grant residents, and again, we're not just talking about members, we're talking about residents, exceptions to HOA policies in deference to their medical condition. That's the big one. The HOA's obligation is to give somebody an exception to an HOA rule because of their medical condition. And the second big piece is to allow residents to modify their own property and limited portions of the common area at their own expense to accommodate their medical condition. And there's very specific procedures you're going to go through with that. But note what I didn't say there. It usually is not the HOA's obligation to pay for modifications to somebody's home or to pay for modifications to the common area for one resident's medical condition. It is the HOA's obligation to grant exceptions to HOA policies. And sometimes that's going to mean allowing them to, the famous one is installing the hardwood floors because I have an allergy to the carpeting. Don't just, roll your eyes at that one. Treat it as a request for disability accommodation. And what you want to do is make sure the residents are being granted exceptions to HOA policies, including by modifying their own property at their own expense to accommodate their medical condition. So best practices here, if there, again, get council involved from the beginning. If there's a request for an exception to an HOA rule, err on the side of granting it. HOA rules say you can't install hardwood flooring, you have to leave the carpeting in. You're going to err on the side of granting the exception with proper guidance from council. If they're requesting to modify their own property or some limited portion of the common area, the classic scenario is I want to, get a wheelchair ramp from my parking space to the front door. You're going to ask them to submit an architectural request so the board can properly review that. That gives the board an opportunity to consider things like building codes, the aesthetic of the community, and so on. But again, the HOA itself usually is not going to be paying for the modification directly. You're going to work with council on the appropriate response to that request, including the relationship between the disability and what it is they're asking for, and whether this poses any kind of an undue burden to the HOA. Don't get bogged down in a question of whether you think the medical condition is real, whether you've ever heard of it before. You're not going to be asking for detailed medical records. You can't ask for detailed medical records. You're going to have us handle what information is being presented and whether it's appropriate to ask for more information. If the HOA is unable to grant exactly what's being asked for, you're going to engage in an interactive process. You're never going to simply deny it. You're going to work with that person to figure out what makes sense for them. And you're never going to fail to respond or make a decision. We had a very big claim against an HOA not long ago where apparently the board intended to grant what was being requested, but didn't for an extended period of time. The delay itself became the problem. So if there's a delay for any reason, you want to give that person a prompt update in writing. And this is very much the end and point of the presentation. While this matters, you've heard me say a few times that there's tremendous potential liability exposure to the HOA for not handling these things properly. And this encompasses both the disability concerns and race or other forms of discrimination concerns. The claimant, the person who's saying I'm being discriminated against or I didn't get my disability accommodation, could recover their out-of-pocket expenses, meaning economic damages, their non-economic damages, which we often call pain and suffering. But regardless of what those dollar amounts are, the statute says, and this is the Unruh Civil Rights Act, they're entitled to a minimum of $4,000 per violation. Okay, what is a violation? Well, that's something the lawyers are going to argue about, but we had a very seasoned disability rights attorney not long ago arguing with case law to back it up that maybe a violation is every day that the request wasn't granted. $4,000 per day adds up very, very quickly. The law also states that the claimant is entitled to 3 times of whatever the actual damages are. So if you've got, in the illustration I just used, a claim of $4,000 per day, and now you get to triple that, now you see how this gets exponentially greater very quickly. The other big piece of this is that the claimant, if they prevail, they're entitled to recover their attorney's fees. The seasoned disability rights attorney I was just talking about is somebody that the courts are familiar with, and there's actual cases where the court approved that attorney's hourly rate of $700 an hour. Sometimes when we talk about 6 or 7 figures for these claims, we're not necessarily talking about just the damages, we're talking about the attorney's fees, where the HOA is on the hook for not only its own attorney's fees, but the legal fees of the person who's suing the HOA. Those numbers add up in a hurry as well. And on top of all those things, you've got the risk of punitive damages, which is a separate dollar amount from what the actual damages are they're claiming, their attorney's fees. This is a dollar amount just to punish the HOA, to make the point to the HOA and other HOAs that you can't do that. These things very, very, very quickly add up almost mathematically to 5 and 6 and 7 figures, things that should have been a very simple administrative decision in the beginning. What is it you're asking for? What exception to the HOA rules do you want? Okay, fine, go ahead and do it. Instead become a legitimate claim for tremendous dollar amounts against the HOA. So general tips, don't shy away from these issues. Meet them head on. Race, disability, any of these issues. The HOA's primary obligation is to look into them and document that it looked into them. Ignoring these situations when they come up is how you get big liability for the HOA. Anybody requests a disability accommodation, you're going to respond promptly to that with proper advice from counsel. Consider having your boards adopt a fair housing policy, which we of course can provide proposals for. That makes sure everybody knows how this is supposed to work. The board, the residents, the homeowners, a fair housing policy makes sure everybody's doing what they're supposed to be doing and everybody knows how it's supposed to work. And of course, the big point you're sick of me saying is get counsel involved early and often. And that is our presentation on that topic. Thanks very much, everyone. Do we have questions? Everybody's just numb now.
Yeah. Nancy, you have a question? I think you're still muted.
There we go. I had submitted it on our Google Sheet, but only slightly before the meeting, so you might not have gotten to it. And you've partially answered it. It has to do by saying the board should adopt a fair housing policy. So I've had a number of discrimination issues among a number of them. And as a result of all of those, the board has been reviewing a code of conduct policy for the residents, a code of conduct policy for the board and committee members, and guidelines for neighbor-to-neighbor issues to get those settled without or before involving the board of directors. And now you mentioned it. So my general question is, what is your advice on that? And it's kind of a technical question. Are those kinds of policies put out for comment? Are they best done how are they best enacted?
Great question. So a couple of things. Code of conduct is a good idea. Nuisance policies are a good idea. They don't quite get at this issue.
Yeah.
What we put together is something that specifically envisions the federal law, the state law, and gives a clear sort of path forward. What are the issues we're talking about and how should they be properly handled by the board? Specifically geared to making sure the HOA is, as much as possible, protected from these issues and knows how things are supposed to work, and the residents know how it's supposed to work. Yes, it would go out for a 28-day comment period like any other policy. It goes through the regular adoption process.
Okay.
The thing to bear in mind there is that, as with anything, part of the discussion we'll be having with the board in response to those comments is, okay, so-and-so doesn't like this piece, that's fine, but here's what the law requires, and here's why the policy was drafted this way. That's going to be the focus, less than people saying, well, gee, I'd like it if it were this way.
I would just also add, having that policy in place not also helps guide boards and homeowners about what to do when they have these situations. But if there's a complaint and the DFEH is investigating the association of where they stand on these issues, what have they done, being able to say you have a discrimination policy in place definitely helps. And you know, we haven't been able to do that, but we would love to be able to put that in a response to a complaint, is that we have this process that we have adopted.
Yeah, absolutely.
And
Penny,
not
you have a
only
question?
you have the process in place, but that you can do something about it. It's a tool by which you can enforce your governing documents and evidence action taken.
Good.
Absolutely. Absolutely. Penny, did you have a question?
Yes. Now with these policies, and you're putting these policies out, and somebody can say, well, I didn't get this policy and I didn't know this was how I was supposed to do it, because you know that always happens. Somebody says, oh, I never received it. What is there a way that you can protect the association if they were to send one and then somebody, well, I didn't see that policy and you know you're just now telling me this? Or
Great question. One thing that's important to remember is that what the law says when you're talking about disability requests or really any of these things, there's no magic language that the resident has to use to make their request. It's on the HOA and the board in consultation with our office and you guys to recognize these things for what they are when they come up. Somebody's saying anything, I've been mistreated any kind of way, get us involved. I need this disability thing, get us involved. As Ann and Colin were just saying, what the policy does is, one, give everyone a clear path forward, and two, it looks like the HOA cares about these issues. Somebody saying, well, gee, I never saw that, so I didn't know, there's not necessarily a protection against that as such, because what the law is going to say is HOA, regardless of whether you had a policy or not, or somebody knew about the policy, you need to respond to their concerns. But part of the hope is that people do see the policy and know, oh, I have this need, and now I know how to contact the HOA and ask for that to be addressed.
Yeah. So just to make sure it's clear, if the association has a policy and someone contacts you, they request something, you believe it's related to, you know, an accommodation issue that should be submitted as part of the policy, you would just, you know, provide them the guidelines. You or the board wouldn't use the fact that they didn't follow the procedures in your policy as grounds for denial or an excuse of why you didn't process it timely. So it's going to still be up to you, especially since you field these requests, to identify that, oh, they're asking for an accommodation, is what, even though they don't use those magic words, they're asking for a reasonable accommodation. And then you kindly steer them towards what they need to do to submit that request.
Yeah, and Paul, I see your question. Just to follow up on this point real quick, the law is also very clear. You can't create a lot of undue obstacles for people in getting the accommodation or whatever it is they need. You can't say, oh, you didn't go through our procedure, so you're out of luck. It's there to be a pathway for everyone, not as a basis to say, oh, sorry, you didn't play by the rules, so you're out of luck here. Paul?
Yeah, and I apologize if this was already covered. I got distracted for a minute there. So you have somebody who is claiming discrimination against a neighbor. We do an investigation and we ask for documentation that will somehow show as evidence that this did indeed happen. Nothing is provided concrete or nothing is provided at all So the investigation is concluded and said that based on lack of evidence, no further actions being taken at this time. But then it happens again the next month. Same person, same complaint about the same neighbor. And it just keeps happening over and over and over again. Do we initiate a repetitive investigation each time this happens? Or at some point, can we wrap it up?
Yeah, that's a great question. And it goes back to what Colin was talking about earlier. The focus from the HOA standpoint is creating that documentation. The HOA tried to look into it and is saying, please tell us everything you want us to know about this concern. You're saying this person is treating you differently because of your race. Tell us everything you want us to know about that, and offering to sit down with them. If there's documents you have, great, send us the documents. They've been sending you harassing emails, texts, whatever. Give it all to us. We want to see it all. And the board reaches its conclusion. We have had situations where somebody's raising the concern and they sort of drop off the face of the earth. What you want to make sure is that in that instance, the HOA had the last word, in the sense of, we've tried to get this information from you. We're still open to getting that information from you. Please feel free to contact us. At the moment, we're not sure what further action we can take, but we're happy to continue this discussion. You want to leave it open-ended. And you want to make sure that you're doing it in a documented fashion, that the HOA is responding to these things. If at a certain point, if they're not telling you what the concern is or what it is you want the HOA to look into, and there's nothing else that in consultation with council, there's a clear path forward, then yeah, there's nothing else to be done. But we want to make sure the HOA had sort of the last word. We're still here. We're still concerned. We're still paying attention. If you want to talk about this, let us know.
Yeah, and Paul, when you're closing things out, like we've done the investigation based on the facts that you provided, the association won't be taking action at this time. You also want to invite, or at least be open, that there may be other situations that can come up, and to contact the association if new information has come to light, because you don't want to just say, we've done it, we're going to close the door, don't bother us anymore. That's what you don't want, that final word letter to appear, is that we've done our job. Don't come back. So
yeah, so just kind of imagine how all this is going to look in front of a judge.
Right.
Exactly.
The way I phrase the letter in this case, and probably should be, is that if you have any new evidence, I outlay the facts to the person who's made the complaint. This is what we found. This is who we talked to. This is what they said. If we're basing this on a misunderstanding of the facts, or you have any new facts or additional evidence that contradicts this, let us know. Right. So then you're keeping it open, like Ann and Lance have said, to allow for the possibility that it's more important that it's like new evidence. If it's a recurring complaint, then it's kind of more of the same. But if there's a new evidence of an old incident or a new incident that has supportive evidence, then it's definitely something that you're going to want to.
And you mentioned that you provided these policies, these fair housing compliant policies. I assume it's the same price per association. Correct me if I'm wrong, but if you want to send me a proposal, I can forward it on to the managers.
Absolutely. And to give you guys a sense of what we hope this process looks like when it works the way we hope it works. There was a situation, I think it was Rhea and I had not long ago, where things were already heating up. Two homeowners were at each other, complaining endlessly, and the one homeowner saying, "I'm getting treated badly by this person because I'm Black," and she has counsel involved. The other person has counsel involved, and the woman is saying, "I'm the victim of discrimination." Her counsel is saying to the other homeowner, "You've said things that are clearly discriminatory in nature. We're getting ready to sue you or pursue appropriate action." The HOA got involved there, and it took a long time to get through it, but the HOA got involved there, and we sat down with both parties individually with their counsel present, documented the whole process. At the end of the day, on the face of the facts the board had before them, there wasn't really a basis to conclude that discrimination was at work. Certainly they were driving each other nuts and were being each other crazy. Discrimination didn't seem to be a factor. So we gave that sort of open-ended letter. We've looked at everything. We can't conclude that this is what's happening. We're not going to take any further action right now, but if something new comes up, please feel free to contact us. And thus far, knock on wood, nothing else has come of that. That's what you want to see happen. You've got the long documentary trail, attorneys are involved, and at the end of the day decide that the The HOA did what it was supposed to do, what was in the HOA's power to do, and didn't pursue it any further. But that's what it looks like when this works the way it's supposed to work. Christine, I think you had a question.
Thank you, and I apologize if you covered this already as well. I came in a little late. I understand we've covered, investigation, and if we rule out discrimination. What if we rule that discrimination is present? What are our duties to enforce? Are we, we don't really have in most of our documents a clear enforcement policy for discrimination. Obviously, we have policies for nuisances, and maybe we can file the discrimination under the nuisance policy and use that as for enforcement. Or do we say, if you don't stop, we're hiring a lawyer and we're going to sue you? Like, what types of ways, if we do find discrimination, can we follow up with on this matter?
You hit the nail on the head. More often than not, you're going to treat it as a nuisance violation. That falls under, what does the HOA have power to do? What the HOA has power to do is to enforce the governing documents. And the simplest, most straightforward way of handling these things when they come up is to treat it as a nuisance violation. We had one, I think I mentioned earlier, where we did send what amounts to a courtesy violation letter. You're harassing this household on what appears to be the basis of their race. That's a violation of the nuisance provision. Please stop. And if that doesn't work, if it persists, then you're going to treat it through a disciplinary hearing and on down the enforcement process. And to give you an illustration of what this might look like, in that particular situation, like I said earlier, one homeowner is complaining endlessly about this other home over and over and over again, same complaints over and over again. And the more the board looks into it, it's not clear that there's anything to be complained about. Complaints of excessive noise, this, that, and the other. Other residents are complaining about it. Other residents don't seem to be experiencing it. And meanwhile, the people she's complaining about are saying this is because of our race. And this is the one I mentioned earlier where, in fact, the person doing the complaining acknowledged that race was part of her concern. But that's what this can look like, is what amounts to discriminatory harassment, complaining about somebody over and over again. And maybe the board is able to conclude that it's because of race, and you're going to say this is a nuisance violation and treat it through your standard enforcement process. But it goes back to, what is the HOA ultimately empowered to do? It's empowered to enforce its governing documents. Usually you're talking about a nuisance violation.
Yeah, and I think it fits exactly. Most nuisance language is illegal and offensive activity, which something like that is definitely would fit in that.
Thank you.
Noxious.
Thank you. That really helps.
Good. Penny?
This is an off the wall question, but we're coming up to budgeting season. Do you, and I know this discrimination thing seems to be kind of a growing thing now. Are you seeing an increase in discrimination calls to you? I mean, should we consider, hey, maybe bumping up? Because some associations don't have a lot of legal, so they don't do legal, put a lot towards budgeting for legal. But I mean, is this something that seems to be increasing, that maybe all associations should consider maybe bumping up legal for budgeting?
Arguably, definitely we're seeing more of it. I think COVID has made everyone a little crazier in general. Not to say that these allegations are. I think people have a lot less patience with each other, and so we're seeing a lot more of things along these lines. We're seeing certainly instances where maybe discrimination per se isn't the issue, but gosh, you folks sure are driving each other crazy, and everybody maybe just needs to back off for a second. In terms of budgeting issues, I don't know how you would forecast factoring it in, but it goes back to this basic point of it's always cheaper to get us involved early on. I have a manager that I know well, and I want to hug her for this because she had a disability concern come up recently and did exactly what we beg everyone to do, called us right away. And at that point, it's fairly easy to deal with and to go through what the law requires and make sure that the HOA is doing what it has to do, but not things it doesn't have to do. It's always cheaper to get us involved in the beginning. So if you're thinking from a budgetary standpoint, it's going to cost a lot more. Somebody's alleging discrimination or has a disability request, and we're going to hope the board sort of stumbles through it the right way and then call legal 8 months from now when it's much more complicated and maybe the DFEH is involved or even there's counsel involved and it's a lawsuit in federal court, which can happen with these things. That's the best budgetary response I can give you. What do you guys think?
I I think it's probably association specific too. You know, I mean, we are all experiencing just the uptick of homeowner complaints, neighbor to neighbor issues. You see that in some of your communities, and for those, you can already point to like, hey, look, these issues keep coming up. We need to get council involved. So you need to consider raising your budget for. So it's not necessarily like we anticipate there's going to be a lot of discrimination or complaints, but you already know that your community kind of needs a lot of guidance on those issues that are coming up already. So that's, and these discrimination allegations are just part of that, I think. Any other questions?
There was one question unrelated on the Google Doc. Since we're running out of time, perhaps, unless there's some burning discrimination questions, we should probably address this one question from one of our managers. Do you have access to the Google Doc, or would you like me to read it to you?
I don't have it offhand, but if you could read it, we can.
Sure. If owners have let lawns die off multiple years due to drought, and now the yard is patches of dirt and weeds versus just a dead lawn, can the HOA demand and enforce that they install landscape elements, even when watering cannot be enforced?
I haven't looked at this one recently, the statute regarding when there's when we're in the state of drought, which I know we are. I think there's limitations of what they can do to require homeowners to spend money. I would have to look at that statute because I think that it doesn't just deal with watering, but other costs involved in enforcing the watering requirement. So I'd have to talk to you on that.
And I haven't looked at the statute recently either, but I seem to recall there's things specifically intended to not punish people for what might be called drought resistant landscaping. So there could be an aspect, and we need to look at it, but there could be an aspect of that law that could actually look very unfavorably on the HOA that tried to pursue the issue that way.
Okay, thank you.
Oh, that was Sarah.
Yeah.
Good question, Sarah. Yeah, I think this is probably an issue that's going to come up quite a bit
More
in
and more.
in the coming months. Yeah.
Yeah.
All right. Well, Nancy, question.
I'm sorry, I have one more question going back to the discrimination issue. Sorry, it's a big thing here. To what extent, I have a couple of questions about doing that initial investigation interview when there has been a claim, asking the complaining resident to specifically give examples of why they are making a discrimination claim. And I think it was Lance, one of you actually conducted that interview in one of your situations. So my question is, to what extent is it okay, I'm going to say it that way, for the manager to do that? Does it have to be in person? Should it be in writing? Can it be a well-crafted email that says, please provide us examples of why you're making that claim? Or should we immediately offload it to an attorney?
Lance, yeah, I think that I've been listening to Lance all day, and I do tend to listen to Lance as much as I can. You're going to want to get your attorney involved, and it's not something we recommend a manager conduct on his or her own.
Okay.
We do definitely involve the managers. It's a fact-finding mission.
Right.
And you want to appear neutral in it to the extent that the manager is an agent of the association. Then and I know that there's maybe not a huge distinction between the attorney for the association, but at least there's a degree of separation in terms of the everyday and the ability to look at it objectively and to have the kind of very factual and delicate questions asked in a way that doesn't antagonize the situation. What you don't want to do is come out of there having more problems because you maybe asked the wrong question or things like that. And I know that sounds self-serving but because of the risks that Lance laid out at the end, you really don't want to take on an interview like that. And you also have to know like what you're listening for, because as I indicated, there's follow-up that comes from that, right? In some cases, the discrimination complaint may be very clear and articulated. In my case, it was just you discriminated against me. So I had to figure out, well, why do you feel that way? And so I didn't know what was going to come and what was he going to say. And so then I had to follow up and do 3 or 4 different kind of, okay, well, that's one instance. Were there any others? And in that instance, who were the witnesses? Who were the documents? Things like that. So it's kind of delicate enough that you really should have an attorney involved. And you can use and it's actually an iterative process as well, because the manager helps you, by being there. I was like, well, I couldn't remember exactly, because you don't have a court reporter. It's not like a depot where you are taking notes, and that's by design. You want to be able to keep it so that you can kind of control the information. But yeah, unless Lance or Ann disagrees with me, I think that you always want to have an attorney conducting all of the interviews, much less the critical interview with the complainant.
I think that's right. And I think the other piece to your point about, how do you document that? I think that goes back to what Colin was talking about at the beginning, where at some point there's going to be a letter, preferably drafted by our office, but on behalf of the board, saying, here's what we found, and here's what we do or don't think we can do with that information.
I can't think of any upside to you as managers or to us as a company or to your client by doing this yourself. This takes a high degree of expertise. So yeah, let's have the experts handle these sorts of situations and stay out of the line of fire. Let the lawyers.
That's what we're there for.
Let us take the risk.
Well, and the other thing I'll say too is don't be afraid of finding out, oh wait, this does seem to be racism. This does seem to be sexism. It does seem to be whatever, because then you're going to treat it as a violation. There's no sort of huge burden that comes on the HOA of having discovered this. You're going to treat it as a governing documents violation. You're going to go through that process. The big problem comes if you don't go through this process of looking into it and engaging those complaints. That's where the big liability comes from.
Right. No, the other issue that we're all dealing with, as I think Penny alluded to, is boards that are in shell shock from their attorney fees. In my case, just from the last year, of these neighbor to neighbor things that they're just proliferating. It's unbelievable. And so, well, why can't you do it, Nancy? What you need to do it. You don't want to spend lawyer. So you have given me the backup that I need to go say, the president of my company and legal counsel has said, no, I'm not doing it.
Well, and there's a practical, it's penny wise and pound foolish, right?
Yeah, I know that.
It's you spend the penny up front, and so that you don't get hit with the pounds at the end.
And it's also a due diligence concern. At the end of the day, this ends up in front of a court. A court's going to look at not whether they came up with sort of the right outcome, but whether they went through an appropriate process. And turning to the professional community manager for legal advice, a court's not going to consider an appropriate process, an appropriate, reasonable inquiry into the thing they're dealing with.
And
all right, we're at the end of the hour. I want to be respectful of our guests' time. So we're gonna wrap it up. I too have another burning question. I would love to extend this, but I want to make sure that we close out exactly on the hour. So I wanted to say thank you to Lance and Colin. We really appreciate you coming in and giving us this great information. It's been very, very helpful and useful to us. So thank you so much. We appreciate it.
thank you.
Thanks for having us.
Happy to do it.
Other questions for us.
Thank you.
All right.
Bye, everybody.
Thanks, everyone. Have a good day.